Hello students, my name is Abhishek Sudhir and I'm an assistant professor at the Jindal Global Law School. Welcome to EPG Pathshala on Civil and Political Rights and Module 17, International and Regional Instruments on the Right to Information. The right to freedom of information is a right that has grown out of the right to free speech and expression. It imposes a positive obligation on the state to facilitate access to information. This module will first introduce you to the right to information provisions in the Universal Declaration on Human Rights, the International Covenant on Civil and Political Rights, and then similar provisions in the American Convention on Human Rights and the European Convention on Human Rights will be explored in greater detail. Finally, landmark right to information laws in the United States, United Kingdom, and South Africa will be considered. The purpose of this module is twofold. First, the module aims to give students an overview of the different international and regional declarations, conventions, and charters guaranteeing the right to information. And two, to introduce students to the right to information laws in countries with a constitutional culture that is similar to India's. Article 19 UDHR. In the first session of the General Assembly of the United Nations, the Assembly, by its resolution number 59, acknowledged freedom of information as a fundamental human right. The resolution stated that freedom of information implied the right to gather, transmit, publish news anywhere and everywhere without fetters. According to Article 19 of the UDHR, everyone has the right to freedom of opinion and expression. This right includes the freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. Right then and there, Article 19 of the UDHR states that, look, the right to free speech and expression is wide enough to include within its ambit the right to information. Not only do you have the right to impart information, but you also have the right to seek and receive information, is what Article 19 is trying to state. Now, let's also come to Article 19, but in the ICCPR. Article 19, paragraph 2 of the ICCPR states, everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas as well, of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art or through any other media of his choice. So here the Article 19.2 basically states, yes, it expands upon Article 19 UDHR and states and actually addresses the medium as well. So you and the mode. So it can be in writing or in print, it can be orally in the form of artwork or through any other media of your choice. Article 19.2 embraces a right of access to information held by public bodies. Now, this is the crux of the right to information in the 21st century. The information includes records held by a public body, regardless of the form in which the information is stored, its source, and the date of production. Therefore, in India, which is a heavily documented society, we have lots of information in writing. We have information that's stored now, at least in the digital age, on computers. So Article 19.2 states the ambit of information includes the records held by a public body regardless of the form. Under the ICCPR, the obligation to respect freedom of opinion and expression, and therefore the freedom of information, is binding on every state party as a whole. It is a binding treaty obligation. Now, what are the responsibilities of the state parties, the responsibility of the signatories to the ICCPR? All branches of the state, that is the executive, the legislature, and the judiciary, and other public or governmental authorities at whatever level, national, regional, or local, have to engage the responsibility of the state party. It's not sufficient for a state party, let us say India, for example, to state, well, okay, the right to freedom of information is applicable to the executive and the legislature, but it is not applicable to, let us say, the Life Insurance Corporation of India, because the Life Insurance Corporation of India is not a branch of the state. Well, the ICCPR is very clear on that. The Life Insurance Corporation of India is being, by virtue of being a government body, a public sector body, basically it's a comes within the ambit and also has to exercise the responsibility of the state party. So access to, let us say, the salary or the perks of the chairman of the LIC is something that the citizens of the country have a right to access. The designation of such bodies may also include other entities when such entities are carrying out public functions. In India, this comes under Article 12 of the Constitution. Essentially, in India, fundamental rights are only enforceable against the state, quote unquote state. So the definition of state is what? Is it just the executive, legislative and judiciary? No. The Supreme Court of India has held that the state includes bodies that carry out public functions. So bodies that receive land from the government, that carry out public functions, that carry out functions such as, say, providing services like associated with the railways, for example. Even, railways in India is public, but aspects of the railways perhaps even, or something like public functions like telecom, for example. So they would say that, yes, okay, you are a public body, although your incorporation as an entity, you might be a private entity, but you are now performing public functions, and by virtue of performing those public functions, you come within the ambit of the right to information. The right of access to information includes a right whereby the media also has access to information on public affairs. Here's what the Human Rights Committee has had to say on Article 19.2. With regard to the obligations of the state parties towards securing its citizens' freedom of information, the Human Rights Committee has said to give effect to the right of access to information, state parties should proactively put in the public domain government information of public interest. In India, we do this. We put up the salaries of the cabinet minister. We put up the assets of cabinet ministers, the assets of judges. As of now, it's on a voluntary basis, but the international covenant basically states that no, there should be, if possible, legislation whereby this information is put out in the public domain to in all the member states. State parties should make every effort to ensure easy, prompt, effective and practical access to such information. States parties should also enact the necessary procedures whereby one may gain access to information, such as by means of freedom of information legislation. So, what are the procedural requirements that need to be satisfied to have an effective right of information in state parties? Basically, here's what Article 19 states. The procedures established should also provide for the timely processing of requests. You should have a set time frame in which the request will be first acknowledged and then processed and actioned. And they said that there must be clear rules that are compatible with the covenant. The fees for requests for information should not be such as to constitute an unreasonable impediment to access to information. You can't have fees such as, say, 5,000 rupees or even 1,000 rupees would be probably an excessive fee to access information held by a public body. Further, authorities should provide reasons for any refusal to provide access to information. You just cannot say, well, we're not going to tell you. You can't say that. And arrangements should be put in place for appeals from refusals to provide access to information as well. So there must be a set and definite structure like there is in India as well in cases of failure to respond to right to information requests. Now, let's come to Article 13 of the ACHR, the American Convention on Human Rights. Article 13 of the ACHR safeguards the right to freedom of information. Everyone has the right to freedom of thought and expression under Article 13 of the ACHR. The right includes freedom to seek, receive and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, in print, in the form of art, or through any other medium of one's choice. Essentially, Article 13 of ACHR replicates Article 19 of the ICCPR. Now, we come to a landmark instrument known as the Declaration of Principles on Freedom of Expression. In October 2000, the Inter-American Commission on Human Rights, essentially the body that oversees the implementation of the ACHR, approved the Declaration of Principles on Freedom of Expression at its 10th regular session in October 2000. This declaration, drafted by the Office of the Special Rapporteur for Freedom of Expression, constitutes a basic document for interpreting Article 13 of the ACHR. So this is a document that is used to implement the scope, the ambit of Article 13 of the ACHR. So what do the principles state? Well, the most important principle is Principle 4. Principle 4 of the Declaration states, access to information held by the state is a fundamental right of every individual. States have the obligation to guarantee the full exercise of this right. This principle allows only exceptional limitations that must be previously established by law in case of a real and imminent danger that threatens national security in democratic societies. So, what is Principle 4 state? Principle 4 basically states there must be a real and imminent danger that threatens national security in democratic societies. So let us say that, for example, there is a war going on, perhaps, or there is a conflict with a neighboring country, and a citizen essentially makes a request for information, and that information pertains to war strategy. That information, if put out in the public domain or given to an ordinary citizen, a civilian, would put national security in peril. Principle 4 of the Declaration on Principles of Freedom, of the Declaration of Principles on Freedom of Expression states, only in such a scenario where there's a real and imminent danger that threatens national security in democratic societies can the right to information request be denied outright. So, let's now come to the Inter-American Court of Human Rights, which, like the Inter-American Commission on Human Rights, is another body set up under the ACHR. And like the name states, it's a court. The Inter-American Court has pointed out that a society that is not well informed is not a society that is truly free. Based on this principle, access to information held by the state is a fundamental right of individuals, and states have the obligation to guarantee it. In terms of the specific objective of this right, it is understood that individuals have a right to request documentation and information held in public archives or processed by the state. In other words, information considered to be from a public source or official government documentation. This is worth explaining a little bit, right? What does it say? Individuals have a right to request documentation held in public archives or processed by the state. So essentially, they don't have the right to private information. Now, in India, for example, you don't have the right to the private papers of Jawaharlal Nehru, which are held by the Nehru Memorial Trust and are under the control of the Nehru Gandhi family. You don't have a right to those papers because they are Jawaharlal Nehru's private papers. But papers that formed a part of the PMO, the Prime Minister's office, when he was Prime Minister of India, those documents are from a public source. They are official government documentation, and as a citizen, if they are possibly they will be stored here in Delhi in the National Archives, you have access to them, basically, is what the Inter-American Court says as far as the ACHR is concerned. They draw this distinction between the source of the documentation, whether it's private and public. So if it's public official government documentation, you have the right to access that documentation. Now, what has the special rapporteur said? The state must also ensure, right, that in a situation of national emergency, the denial of information held by the state shall be imposed only for the time period strictly necessary under the circumstances and should be changed once the emergency situation has passed. So now let's take the situation in South America, where currently there is a conflict going on between Bolivia and Peru. So there's a conflict between Bolivia and Peru. Then the head of the Bolivian government over there essentially states that, okay, we will not disclose certain documents relating to the conflict because it will imperil national security. Evo Morales, basically, of Bolivia, right? He says, I'm not going to disclose details relating to this conflict. Now, let us say 5-6 years from now, that the sort of dispute with Peru, which is over oil, basically ends. So what happens then? Evo Morales, if he's still in power, cannot refuse to disclose these documents. There must be a strict time limit set. The special rapporteur has recommended that information considered classified should be reviewed by an independent legal entity, right? They've said recommendation, right? The information that you say, yes, this is classified information which will threaten national security, so we won't review it. Well, the special rapporteur says there is a need for a sort of an ombudsman or an independent legal entity to review that classified information. That independent entity, completely separate from the organs of government, right, should be capable of weighing the interest of protecting civil rights and freedoms against national security concerns. That's what the special rapporteur has recommended. Now, let's come to Article 10 of the European Convention on Human Rights. Article 10 of the ECHR states as follows: everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing of broadcasting, television, or cinema enterprises. So Article 10 of the ECHR departs, well, departure would probably be a strong word, but moves away slightly from the ICCPR and in fact imposes a stricter requirement and says that you cannot have interference by a public authority when it comes to the dissemination of information. Now, Article 10 also explicitly states that licensing of broadcasting, television or cinema enterprises does not constitute interference. See, what this basically means is tomorrow, if you need a license to broadcast a program or you need a license to open a cinema, for example, under the European Convention of Human Rights, countries in member states, citizens in member states of the European Union can basically claim that, oh, you're asking me to license this, right? I am disseminating information. You're not letting me disseminate that information because you're asking for it to be licensed. You're asking me to pay a very hefty fee. So ECHR, to be on the safe side, simply states explicitly, this article shall not prevent states from requiring the licensing of broadcasting, television or cinema enterprises that is permissible under the convention. Let's look at the case of Leander v. Sweden. In Leander v. Sweden, with regard to the right to receive information under Article 10 of the ECHR, the European Court of Human Rights in Strasbourg held that the right to freedom to receive information basically prohibits a government from restricting a person from receiving information that others wish or may be willing to impart to him. What does that mean? You cannot restrict a person from receiving information that others wish to or may be willing to impart to him. Basically, you cannot impose a restriction on exchange of information between two private parties, is what they're trying to say. Article 10 does not confer on the individual a right of access to a register containing information in his personal possession, nor does it embody an obligation on the government to impart such information to the individual. That's what they say in Leander v. Sweden, straightforward enough. Now, let's come to the landmark Freedom of Information Act in the United States of America. It came into force on Independence Day, 1966, July 4th, that is, and it is the Federal Freedom of Information Law in the United States. Those of you familiar with the structure of the United States know that there are federal laws and state laws. Well, the Freedom of Information Act is a federal law. The statute allows for the full or partial disclosure of previously unreleased information and documents controlled by the United States government. This is key, right? You have the right to information that has been previously unreleased, the right to documents previously unreleased, as long as that is controlled by the US government. Agencies within the executive branch of the federal government, independent regulatory agencies, for example, the federal FEMA, the Disaster Management Agency, for example, or the EPA, the Environment Protection Agency in the United States, and some components within the executive office of the president are subject to the Freedom of Information Act. So you can make freedom of information requests in the United States to the executive branch of the US government, to independent regulatory agencies, for example, right? Now, government controlled. What does that mean? In order to determine whether a non-governmental entity qualifies as a government-controlled corporation, courts are encouraged to consider the following factors: whether the entity performs a governmental function, whether there is substantial government control over the entity's day-to-day operations. So essentially, you have a lot of private companies now in the United States, solar energy being one such field in the US, where the government is actually funding them heavily, right? Just funding, is it sufficient? Probably not. You have to look at the day-to-day control that the government exercises on that corporation, and if the government exercises that control over that corporation, right, essentially what they say is that becomes a government-controlled corporation, and all documents and information held by that government-controlled corporation will also be subject to the Federal Freedom of Information Act in the United States. The court has also said you have to look at whether the entity has the authority to make and implement decisions on behalf of the government, whether the entity's employees are in reality federal employees, right? Are they employees of the federal government? The government's financial involvement with the entity, and whether the entity is federally chartered. So it's not just the financial backing that is given to that entity by the government. You have to look at the nature of the employees. What is the nature of their employment? How is that entity set up? Is it set up under a federal act, even though they call it a private entity? Well, so these are questions you need to consider. These tests were laid down by the US Supreme Court in the case of Montgomery versus Sanders. Here you're looking at a cartoon of the Freedom of Information Act. Freedom of Information Act has been very much in the news in the United States recently, with President Barack Obama repeatedly turning down requests under the Freedom of Information Act were pertaining to drone strikes on foreign soil. So this has proved a contentious issue, and in the age of WikiLeaks, the Freedom of Information Act is very much the front and center of the national consciousness in the United States. Now, let's come to the United Kingdom, where the act is also known as the Freedom of Information Act. The UK's Freedom of Information Act was adopted in November 2000 and went fully into effect in January 2005. The Freedom of Information Act in the UK gives any person a right of access to, again, information held by public bodies. The Act contains, however, 13 pages of exemptions in 3 categories. Under the absolute exemption category, court records and information that is about the personal life of individuals relating to or from the security services, where disclosure would constitute a breach of confidence or protected under any other law, cannot be disclosed. So, interestingly enough, if those of you would remember, Prince Harry, who is now currently, if I'm not mistaken, 4th in line to the British throne, was deployed in Afghanistan. Right? So, did the people have a right to information of that deployment of Prince Harry? Should they know who the individuals who are being deployed in Afghanistan and Iraq? That would come under the absolute exemption category, because information that is about the personal life and relating to or from the security services. So, you probably would extend that to the absolute exemption category. And that disclosure would constitute a breach of confidence, basically. And in fact, newspapers that became aware of Prince Harry's deployment to Afghanistan imposed a moratorium, a unilateral moratorium, wherein they said they would not publish any stories of Prince Harry's deployment in Afghanistan, because that would be a direct threat to his life, and terrorist organizations in Afghanistan would essentially target him. So, the freedom of information in the UK is by no means absolute, and they have 3 categories of exemptions. I've just explained to you the absolute exemption category. The second category of exemptions is the qualified class exemption. Under the qualified class exemption category, information can be withheld if it is determined to be within a broad class of exempted information, including relating to government policy formulation, safeguarding national security, investigations, royal communications. For example, again, we spoke of Prince Harry, right? Royal communications. What's going on? What is Queen Elizabeth saying to Prime Minister Cameron? Legal privilege, public safety, or was received in confidence from a foreign government. Again, this brings to mind a recent incident where certain papers were released in the United Kingdom that showed the involvement of Margaret Thatcher, of all people, in the 1984 Operation Blue Star, where the Indian Army was sent in to essentially into the Golden Temple in Amritsar, right? And these documents came to light. This was sensitive information received from a foreign government in the United Kingdom, that foreign government being the government of India of that day, headed by Indira Gandhi. So that information is a qualified class exemption, and they can choose not to actually release it under the Freedom of Information Act, because they said this is information we have received in confidence from a foreign government. How can we be expected to engage in diplomacy if we are disclosing sensitive information that foreign governments are giving to us, essentially? The third and most important category of exemptions is the public interest exemption. The public interest test applies and provides that information can be withheld only when the public interest in maintaining the exemption outweighs the public interest in disclosure. It is a weighing, right, of the public interest in disclosure versus the public interest in non-disclosure. Very simple. Is there a greater public interest in disclosure, or is there a greater public interest in non-disclosure, right? The third category is a more limited exemption, where the government body must show actual harm, actual prejudice to specified interests to withhold information, right? They have to say, okay, we have to be specific. Oh, it's not enough to say, this is, sensitive information. No, there's a public interest balancing act that has a balancing test that needs to be carried out, right? So what kind of information will apply or will come under the ambit of the public interest test? Well, the information relating to defense, international relations, economy, crime prevention, commercial interests, or information that would prejudice the effective conduct of public affairs or inhibit the free and frank provision of advice. The public interest also applies to information in this category, right? Here, you're looking at an expose by the Daily Telegraph in the United Kingdom in the year 2009, which made big news in the UK that year. The Daily Telegraph ran a headline, and you can see it there, "The Truth About the Cabinet's Expenses." It disclosed kind of frivolous expenditure that members of the cabinet were undertaking on the public dime, basically on government money, and this information came to light because of a freedom of information request, and that request was granted because it did not come under either the absolute exemption, the qualified class exemption, or the public interest exemption. They felt that there was a greater public interest in actually disclosing the cabinet's expenses because the people of the United Kingdom, the taxpayers of the United Kingdom, had a right to know what their elected representatives, what the executive was doing with their money. Now finally, let's come to South Africa. Section 32 of the South African Constitution of 1996 states, "Everyone has a right of access to any information held by the state, and B, any information that is held by another person and that is required for the exercise or protection of any rights." This is revolutionary because it says not only do they have access to information held by the state, but you also have access to information that is held by another person, which means a private person, as long as that information is required for the exercise or protection of any rights. So the right to freedom of information extends to private entities and persons in South Africa. National legislation must be enacted to give effect to this right and may provide for reasonable measures to alleviate the administrative and financial burden on the state. Therefore, they simply say there must be national legislation. So the South African Constitution is one of the few constitutions, right, of the world which explicitly states that there must be right to information legislation. It does not go to the extent of actually defining the contours of this legislation, but simply states that you must give effect to the right of access to information, and now is explicitly stated in the South African Constitution of 1996. And it also states that this national legislation may provide for reasonable measures to alleviate the administrative and financial burden on the state. In furtherance of the mandate under Section 32 of the Constitution, South Africa has enacted the Promotion of Access to Information Act, the PAIA, and it was approved by their parliament in February 2000 and went into effect in March 2001, within 5 years of the Constitution coming into force. What does the Promotion of Access to Information Act state or do? It implements the constitutional right of access, and in the words of the Act itself, is intended to foster a culture of transparency and accountability in public and private bodies by giving effect to the right of access to information. See there, once again, it applies to private bodies, and it actively promotes a society in which the people of South Africa have effective access to information to enable them to fully exercise and to protect all of their rights. Under the Act, any person can demand records from government bodies without showing cause. There is no need for any reason. State bodies in South Africa currently have 30 days to respond to any such request. The Act also includes a provision that allows individuals and government bodies to access records held by private bodies when it is necessary for the exercise or protection of people's rights. And amazingly enough, private bodies must also respond within 30 days in South Africa. However, the Act does not apply to records of the cabinet, much like in India, and its committees, judicial functions of courts and tribunals, and individual members of parliament and provincial legislatures, right? These are decision makers in government, essentially, and the Act says it does not apply to these people. The cabinet and the committees, which is the executive, the judicial functions of courts and tribunals, the judiciary, and the individual members of parliament and provincial legislatures, that is the legislature. So the Act does not apply, essentially, to the three organs of government, basically. There are a number of mandatory and discretionary exemptions for records of both public and private bodies. Most of the exemptions require some demonstration that the release of the information would cause harm, much like in the UK, actual prejudice, right? What are these exemptions? Personal privacy, commercial information, What is commercial information? Trade secrets, right? You cannot apply to Coca-Cola in South Africa and say, tell us your formula, or you cannot apply to Kentucky Fried Chicken, KFC in South Africa and tell them, tell us the formula, how do you make your fried chicken? Because that's commercial information. That's a trade secret, right? Confidential information, safety of persons and property, law enforcement proceedings, legal privilege, defense, security and international relations, economic interests, and the internal operations of public bodies are all exempt from disclosure. Many of the exemptions are balanced again against the public interest test, right? Public interest in disclosure versus public interest in non-disclosure, and a failure to comply with the law, right? If the information shows a serious contravention or failure to comply with the law or an imminent and serious public safety or environment risk, basically. Right? So there's a real risk that if this information is disclosed, right, there's going to be a problem. There's going to be a national security threat or a public order problem, right? Then only you do not disclose this information under the Act. Right? Let's quickly look at a case, the Institute for Democracy in South Africa versus the African National Congress. In this case, the Institute filed seeking to establish the principle that political parties were obliged to give details of substantial private donations under the Act. This has also been an issue in India, and the court found, that is in South Africa, the court found that political parties are not public bodies under the Act, and alternatively that the information was not required for the proper exercise of the right to vote. Right? What have I said earlier? Private bodies, right, non-public bodies can also come under the ambit of the Information Act in South Africa. So political parties either way should come, right, even if they're public or private. But if they're private, the information held by them will only be necessary if it is required for the proper exercise of a right under South Africa's constitution. What is one of those rights is the right to vote. But the court said no. How is the disclosure of their private donations going to, improve or sort of aid your right to vote? It's not. And they said political parties as private bodies, the court held in South Africa, were under no disclosure obligation under the law, unlike in India where the courts have held that they are in fact under the ambit of the Act. Now, quickly, the South African Human Rights Commission is essentially tasked, right, with overseeing the implementation and enforcement of human rights in South Africa. Public and private organizations both must publish manuals describing their structure, functions, contact information, access guide, services, and the description of the categories of records held by the body. The manuals are submitted to the South African Human Rights Commission and published in the official gazette of the government. The South African Human Rights Commission oversees the functioning of the Information Act and is required under the law to in fact even issue a user's guide in all of the official languages of South Africa, such as Swahili, English, and Afrikaans. It must also submit annual reports to Parliament and can promote the Act, make recommendations, and monitor its implementation. So, students, we come to the end of this module. This module has demonstrated how the right to information has emerged as a key civil and political right in the 21st century. We are, after all, in the age of information. This right, as has been shown, has been given effect in not only international instruments but also the domestic laws of various developed and developing nations, and nations such as the US, UK, and South Africa that come very close to the constitutional culture that we follow. The right to information is now at the very center of the movement to affix responsibility and accountability within the government machinery. From the US to the UK and South Africa, it has been given pride of place in the pantheon of human rights. There are exceptions. We've discussed these exemptions, and most of them centering around the public interest tests. The public interest for disclosure, public interest in favor of non-disclosure. The judiciary has played a key role in ensuring that the exception does not eat up the rule, however, and the courts in all of these countries have held that the right to information can only be curtailed when there is a public interest in non-disclosure.